And let me once again welcome everybody officially to today's online event, Sexual Violence and Evidence Collection. This event is part of our series on sexual violence, sponsored by the National Institute of Justice and the Government Innovators Network. I'd like to pass control over to today's moderator, Sergeant Joanne Archambault, who is the founder and executive director of End Violence Against Women International.
Hello. I'd also like to welcome everybody to this webinar. We're very excited about the positive response and the number of people. I'm just going to provide a very brief overview. We're going to first hear from Sergeant Jim Markey from the Phoenix Police Department. And Sergeant Markey is going to talk to us about the importance of multidisciplinary collaboration, scientific advances in collection and analysis of physical evidence, including national databases, and he'll also be talking about the general goals and specific techniques for crime scene evidence collection. Then we'll hear from Jennifer Pierce-Weeks, a sexual assault forensic examiner, and she, of course, will also be talking about the importance of multidisciplinary collaboration. She'll discuss both parts of the forensic examination, the medical components as well as the forensic evidence collection, and we'll also be discussing implications of VAWA 2005 and anonymous case processing. And then we'll hear from Roger Caniff, Deputy Chief from the New York State Attorney General's Office, and he will also be talking about the importance of evidence collection, types of physical evidence available to us when investigating and prosecuting sexual assault cases. He'll be talking about what prosecutors need for evidence to be used successfully during prosecution and what forensic examiners should expect from prosecutors. So we'll go ahead, and if we could hear from Sergeant Markey.
Thank you, Joanne. And first of all, I'd like to thank the Harvard Kennedy School Ash Institute, as well as the National Institute of Justice, for allowing me this opportunity to be a part of this panel of experts. I really don't consider myself an expert only by default because of the position I've been in for the last 10 years. With that in mind, we have seen those who have worked in this discipline and field of sexual violence for the last few years have seen a lot of evolution occur. I think there is some more steps we can take, obviously, to make these investigations much better for the victim, the treatment, the care, and obviously we want to hold offenders accountable for their actions. Let's see if I can get this next slide up. I just wanted to do a quick overview kind of where we're at and where I think, or hopefully, people will be at in the near future, if not. And one of the things I'd like to emphasize on this particular slide is the multidisciplinary teams. This really is not, these types of investigations are probably some of the most difficult crimes to investigate, and they really need a team approach. And I think if individual jurisdictions or however you approach these types of crimes, if you have specialized units, if you're utilizing forensic nurse examiners, victim advocates, and now, especially I know in our jurisdiction here in Arizona, within Maricopa County, we actually have 6 advocacy centers where we actually do the examinations and conduct our investigations out of. I think those are key components for this team in order to really provide the service and provide the investigation that's appropriate and needed for these types of investigations. We know that there's been advances in science. We're doing much more with much less. There's greater analysis capacities. But I think at the same time, what we're seeing is in a lot of our jurisdictions is the CSI effect. I think there's an expectation from the community, from our victims, from other people within these disciplines that they're expecting a lot more from us because of what they see and what they read. And it is occurring. There is physical evidence through, obviously, DNA. We're talking some Y-star mitochondrial, and now one of the big things is touch DNA, and how much farther is this going to go scientifically in the future of what we'll be able to collect and what we'll be able to analyze. We've had cases with animal and plant DNA, and we've solved them with those. But we still, as law enforcement, can't forget fingerprints as well as key elements in evidence collection and identification. But I think there is an expectation and a responsibility that we, within the law enforcement community, are trained and can collect and have these items examined in order to try to resolve these cases. I always tell people it's better to collect and collect as much as you can and not submit it or have it submitted later than not to collect it at all. And of course, there's expanding searchable databases, and everybody should be familiar. NIBINS is the ballistic database that links firearms. But with many states now going to all arrestees for collection of DNA, these databases are going to become more friendly to law enforcement in solving cases. But there are some expectations, I think, for law enforcement. And hopefully everybody is making steps in the direction to create these multidisciplinary teams to ensure that your investigators and others are cross-trained within that team and are specialized in understanding the dynamics of these types of crimes that occur, the emotional impact, the intimacy of the crime and how it's occurring. And I think one of the big issues is overcoming consent. That's always been one of the hardest parts of these crimes to try to prove. And I think through good crime scene methods and techniques, through good interview techniques, through good follow-up investigation, I think we're in a position where we can at least start to overcome a lot of the consent defenses that are coming out there. I think there's also an expectation that we're objective and we're fact finders. We're unbiased. Law enforcement is not or are not advocates. We are not nurses. We have a job to take the facts, the evidence of the case, and objectively look at it and make that determination along with the prosecutor as to whether these cases can move forward. And I also warn or tell folks, don't just stop at DNA. If you're an investigator, you're a detective, go out and detect. A lot of times our crime labs are getting backlogged with old cases, and what's happening is maybe the investigators are saying, well, I'm just going to wait till I get an answer from the crime lab. Don't do that. Move forward with your investigation in spite of the evidence that may be there or not. So when you're talking about the crime scene, obviously if you've been involved in this area at all, you understand that there could be multiple crime scenes involving multiple locations. And of course, what we have seen in the past is obviously our victim that comes forward is probably our number one crime scene. And the collection from that victim and the chain of custody that's developed when those exams are being done is so critical in solving some of these crimes. So really, our crime scene goals, what are they when you're looking to go out and collect evidence? And it's pretty basic. Everybody should be familiar with Locard and his theory of exchange, and the fact that any time objects come in contact with each other, one's going to take and one may leave certain items of evidentiary value. I guess the difficult part is finding those items and then interpreting what those items mean to us. And that's where you get into reconstructing what may or may not have occurred at a particular crime scene. It also helps us to corroborate any statements as we've gotten from victims, from witnesses, or from suspects. And that becomes very critical when consent now becomes an issue with a lot of these cases. And if you can lock a suspect into a story, and then through your physical evidence prove that he was being deceitful or that he was not being honest with the investigators, then I think you're at the advantage at that point. I just think I have a couple more slides. Considerations for your crime scene. Management, protection, obviously identifying and documenting the evidence. And I know that Roger will talk about the chain of custody. Bottom line is if you can't get it into court as an investigator, the evidence is probably not going to be very useful in that matter. So that is a key component for your crime scene in managing it as well. Some of the crime scene rules that we try to go by, first of all, if you're collecting evidence, you need to protect yourself. There are all kinds of diseases, and now MRSA is becoming very big at crime scenes, so really protecting yourself is a key element that we try to emphasize with our investigators. And prevent contamination. I think one of the, for the time being, I don't think a lot of the defense has been able to solve DNA and how to attack it in the court. So what are they going to do? They're going to attack you as the investigator and how you contaminated it or how you move or altered items. And that's going to be the issue as opposed to whether the suspect was guilty or innocent. It becomes an issue of law enforcement and how they may or may not have collected items. But you have to remember that the physical or the forensic evidence never lies. And so based on that, you want to develop a hypothesis of what may or may not have occurred in the case. And really, with a crime scene, you really only have one chance to collect those items. And you can't go back and try to recollect items that you missed or that you weren't trained or had not had the experience in collecting. So with that, I will put up some resources that are very good that we have used as far as evidence collection and mainly with DNA and DNA technology. And with that, I will pass it back to Joanne.
And I think that we'll just go ahead and hear from Jennifer next, actually.
Thank you, Joanne.
Yes, so audience, feel free to ask questions or start posting your questions.
Like Jim said, I would like to thank Government Innovators Network and the National Institutes of Justice for inviting me also to speak on this topic. And like Jim, expert by default and practicing on sexual assault victims for the last 15 years as a registered nurse and SANE nurse. So just in going straight to the topics that I really want to cover briefly so that we can chat with people in regards to their questions. I agree with Jim that the team approach really is very critical. And so my list in front of you is probably slightly out of order, but I really want to build on what he said about that because I see several influences happening in our practice that I think it's critical for the team to understand, and it's critical for nursing and medicine to understand as we practice on this patient population. One of those things is that different team members can have significant influence on the practice of nursing or the practice of medicine. And we see this very commonly. A lot of people think that, say, nurses are an arm of law enforcement, that we are somehow a law enforcement entity versus a nursing professional. And that is something we need to address in a major way so that we can better care for this patient population. My focus in nursing needs to stay on patients and their health care needs. And while evidence collection for sexual assault patients is part of that, healthcare is not the entire package. The entire package involves all of their healthcare needs, including evidence. So while we do separate out the medical and the forensic components of the exam, the truth of the matter is there's no way to completely separate them. There is no other professional that's going to take on the evidence collection from a sexual assault victim's body in a living victim other than, say, nurses or forensic examiners of varying disciplines. And so we need to try to really meld that medical forensic back together versus separating it out. One of the reasons that I say this is that when victims of sexual assault present to emergency departments or even community care settings complaining of sexual assault, they're coming there for health care. And I think that Roger, when he speaks, will concur that we want them there for health care, that the purpose of the medical exception to the hearsay rule is that the statements they make to me in healthcare, in a healthcare diagnostic and treatment setting, can come in at that criminal trial. And so we want it to be the healthcare setting. We do not want it to be that we have become law enforcement officials. And so that's one very critical piece from my perspective, and I think best practice dictates that combination of medical forensic care, comprehensive care for victims of sexual assault is being given in a variety of settings with nurses, with physicians assistants, nurse practitioners, etc. So just really keeping that molded model of medical forensic examinations for these victims as our best practice, and appreciating that CSI influence that Jim talked about, that expectation of DNA is not necessarily the evidence that you're going to acquire in these cases. And I will give you an example, and I think that I say this not only to the examiners on the call, but to the other disciplines, because it really is critical that different roles understand what we do and the importance of it. A recent case that we had was a woman who was from out of state. She actually was out of state when she was sexually assaulted. She was about 43 years old, and she was held by her by the suspect for 3 days and repeatedly sexually assaulted in a variety of ways over that 3-day period of time. 2 days after she was able to get away, she went to a family practice doctor who said there really wasn't anything that he could do for her. And I think family practice doctors are not necessarily educated in this area. And 7 days post the assault, she came to our emergency room. And she was in a severe state of anxiety, but she was also still complaining of genital pain. And if we stuck with the idea that we can only collect evidence, quote unquote, 3 days out from the assault, we never would have seen this woman. And I hear story after story of patients who are not seen because the window of evidence collection has passed by. And I think, and right after this, I will hand it over to Roger, and perhaps he can comment. But she had 7 days after her sexual assault significant genital and body injury that we were able to document. That certainly isn't going to produce any DNA, but I think it's fair to say that it would be critical evidence in the prosecution of that sex crime. So I think the importance of the team, the importance of our individual boundaries and our individual roles on that team, and the education of the team on what those roles are, is just really critical to us improving the practices we currently have in investigating and prosecuting sexual assault cases. And I think that, and Joanne, please correct me if I'm wrong, I think that we were leaving the VAWA compliance issues till after the fact, after the team. Is that correct?
I think that's fine, Jen. If we want to leave it to questions to guide us as to what the audience wants.
Oh, okay. It's up to you. I'm happy to do it now or not. I just got the impression we were doing it after.
I think that's what we agreed to also.
Okay.
And just so the audience knows, I was advised that at one point I came across very soft, so I'm hoping this is better. I'm not sure. I haven't changed anything, so I'll just try to speak up. Thanks, Jen, for that. And Roger, if we could hear from you.
Sure. Thank you, Joanne. And hello to everybody who's in attendance. And again, I echo also the thanks to the Government Innovators Network and NIJ. This is very exciting. What I want to talk about is I definitely want to pick up from where Jen and Sergeant Markey left off and talk a little bit about the legal aspect of this, kind of where the rubber meets the road with regard to where the clinician's work enters the courtroom. And of course, the bridge between what the clinician does and how it gets into evidence includes law enforcement. It includes victim advocates, and it's definitely very much a team approach, or it should be. Ideally, it's a team approach, as Jim mentioned. without a doubt, physical evidence really has kind of emerged as the ADA's most formidable weapon in sex crimes cases. And I want to stress here at the top that that being said, all evidence is valuable in a sex assault prosecution, as you see here. And we note to juries when we do voir dire, do you guys understand that testimony, testimony from the sexual assault survivor, the victim, the patient, whatever term is used, their testimony is as hard evidence as anything else. But the fact is, as a practical matter, medical and physical evidence often ends up to be the most compelling piece, particularly in an identity case where, and those are rare. I mean, to be fair, as we all know here, most sex assault cases are committed by people who know one another. But they're sometimes the most egregious and the most scary cases are the ones where the perpetrator is unknown, and therefore medical and physical evidence is absolutely crucial. And of course, it can also be invaluable in acquaintance or consent event cases. And what do I mean by that? Well, a lot of times what is gleaned from the body as a crime scene, as Jennifer Pierce-Weeks touched on just a moment ago, can be crucial in making it clear to the jury that the act that the defendant, that the perpetrator claims was consensual, was in fact not. In other words, very severe genital trauma in rare cases. That's kind of a nettlesome issue, but sometimes more importantly, just things like finger marks around the wrists, bite marks to the breasts, or places where hair has obviously been torn out, things like that. A lot of times it's the non-genital injury, and it's the head-to-toe exam from a really, really conscientious, sane, or safe that makes the case for us, because the jury can hang their hat on that and say, wait a second, if this was a consensual act, that sane picked up finger marks on her wrist. She picked up a deep red mark where her bra strap would have been. Those aren't things that occur between people who are in a consensual situation. So oftentimes that physical evidence, even if it's non-genital and even if it's not necessarily DNA, is extremely valuable. Yeah, DNA is fantastic. It is what juries envision to be the kind of hook for all cases. As Jim talked about a few minutes ago, the CSI effect is something that as prosecutors we have to be aware of. We voir dire on that as well. Do you all understand that not every crime is solved the way perhaps you've seen it on read in books or seen on television or things like that? Does everybody understand that there isn't always this kind of evidence? Sometimes there is. If there is, we can use it. Sometimes there isn't. But it definitely has to be considered, and it is something that juries expect more and more will come into the fray. Well, if we know it's this guy, why didn't he leave something behind? Or why wasn't somebody able to find something? There should be somebody with a pair of glasses and rubber gloves on that's somehow come up with something here. So we've got to be aware of that. The most commonly utilized forms of evidence, of course, evidence that can be analyzed for DNA identification is very valuable to us. Evidence of physical trauma, like I referred to about a second ago, and whatever corroborates and supports the victim's account. So, like I said, if you have a mark where a bra strap was pulled very cruelly, very forcefully across the body, or if you have finger mark bruises, or if you have evidence of torn hair, or other things, anything can found on the victim's body, again, viewing that body as a crime scene, anything can support and corroborate what the victim claims occurred. And what you see up here are things like surface materials, road gravel, torn clothing. She says she was forced to her knees and her knees were being ground into a rough parking lot. What does the clothing reveal to us? Does it in fact show something that would support that account of events? It's very possible that it does. Foreign objects that land on the body in the form of anything. It can be, who knows, it can be spit or saliva from the perpetrator. It can be hair, carpet fibers from the inside of a vehicle, the inside of an apartment, a hotel room, anything like that. All right. What prosecutors need, this is what prosecutors desperately need from clinicians and those who are collecting physical evidence. What we need are the things that you see here, a clear, unbroken chain of custody. Courts are very concerned, and defense attorneys are very aggressive at trying to get at the chain of custody. If we can't show that the evidence has been properly handled, if we cannot show that it is passed unmolested and unaltered and carefully from one professional to another, we've got a real problem, because then the jury may not be able to have confidence in it. And even if the court allows it, because remember, it's a two-step process. First, the question is for the court, can this come in? And the defense attorney, if there's an unclear chain of custody, or if there's a period of time where the evidence was not properly cared for, it's very possible that the defense attorney will say, look, judge, the jury shouldn't see this evidence. You, judge, you're the gatekeeper, and you should keep this evidence away from the jury because it's been compromised, because it was laying around in an open drawer all night, or because it was not properly labeled, or for whatever reason. The judge then, he or she makes a decision as to either say, you're right, the jury should be shielded from this evidence because they simply can't depend on it, or no, I'm going to let the jury have the evidence, I'm going to let them see it, but it's going to go, objections to it are going to go to weight, not admissibility. In other words, the defense attorney will be able to cross the clinician and say, well, but this wasn't correctly handled, and therefore they can put a doubt in the mind of the jury as to whether or not the evidence can be trusted. So therefore, a clear, unbroken chain of custody is incredibly important. Secondly, we absolutely need clinicians and examiners to adhere to any written or accepted workplace protocols. Why? Because defense attorneys will get that stuff in discovery. They will seek out and find out what the written protocols are. And a lot of times these protocols are very old, they're not updated very regularly, but they should be updated and they should be known. Please, 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 every forensic examiner needs to understand and absolutely follow their workplace protocols. And the reason for that is because even if you're doing the right thing from a medical standpoint, from a forensic standpoint, even if you're doing the right thing, if you're not following the protocol exactly, that is yet another hook that the defense can sink their claws into and say, look, this individual simply doesn't follow the protocol that she's directed to follow. So even if she does or has appeared to have done what's right here, the fact is we can't trust this, because if she can't follow the rules of her workplace, how do we know that she's done this correctly? Again, it can be silly what defense attorneys will go after, and not to criticize defense attorneys, by the way. I have great respect for the profession. They're doing a job that's not easy to do. But in terms of when you're in an adversarial situation, what defense attorneys will go after is, they're ethically bound to exploit whatever they can within ethics and the law to protect their client. And what they will go after and what juries will hang their hat on can be really interesting. And then finally, we need utmost care, absolute care, when handling and labeling and transporting any sort of physical evidence, anything. Because here again, if there's evidence that the physical evidence was not handled properly, was not labeled properly, here again, you're going to cast doubt on it. It could be so much doubt that the judge will shield the jury from it, or it could be that the jury will be able to see it, but again, the defense will be able to weaken the effect of the evidence. All right, moving on then. What else do prosecutors need? Well, these last two slides are just some brief comments on what we hope forensic examiners will bring to us. This is what we hope forensic examiners, this is how we hope forensic examiners will appear and carry themselves. We want forensic examiners who are medical professionals who, as you see here, treat patients with competence, professionalism, and compassion, but who also maintain a sense of objectivity. And I think, Jen Pierce, we've commented on this a little bit. It's very, very important for sex assault nurse examiners and forensic examiners to understand that they are not adjuncts of law enforcement. They are neutral, objective, scientific observers, and they are healthcare providers. They are medical professionals. They treat a patient. A sex assault nurse examiner or a SAFE should never use the word victim and should absolutely never use the word survivor. Those are appropriate terms. They come out of the movement. There's nothing wrong with them, but they don't have a place in the medical world. SANEs refer to their patient as just that, a patient. And what they do for the patient, they do for the sake of good medicine. And it's a very, very difficult line, but some of the best professionals I've ever seen are SANEs who walk this line very beautifully, where they wear two hats. On one hand, they're treating their patient, they are doing what's appropriate medically, they're caring for that person, and they're not expected to be robotic. No one is expected to be neutral about sexual violence. If you're treating someone whose chief complaint is sexual violence, you treat them with compassion. But at some point, the SANE does have to stand back, put on their scientific examiner hat, and just objectively look for what the body is going to give them as a crime scene, and take that evidence and understand that that evidence will go to either side. It's going to go through law enforcement to the prosecutor, that's true, but then it's going to be shared with the defense attorney in discovery, and it's going to be given to the court in the court search for the truth. So that too, safes have to be comfortable with interacting with defense attorneys, interacting with the court, and understanding that their evidence might be beneficial to the prosecution. Most of the time it's neutral, and in rare cases it might actually be beneficial to the defense, and if so, they have to be prepared to testify and cooperate with any of the litigants who require that evidence. We also ask that forensic medical professionals be ready to cooperate with the prosecutors and the defense attorneys, as I mentioned, and be available for clear, objective, and expert testimony as needed, or lay testimony as needed. Lay testimony simply being non-expert testimony, just observations. Okay, finally, what safes should expect from decent prosecutors are the things that you see here. Prosecutors should be willing to learn about what safes do. They should be willing to learn about the protocols, the procedures, and the techniques while they're prepping. They should be willing, in my opinion, to go to the facility, to go to where these things happen in the clinic, to go to the hospital, to go to wherever the exams are conducted. I realize that in rural areas this can be more difficult, and everybody has to kind of shape their practice to what's appropriate for them. But I suggest that prosecutors actually go and roll up their sleeves and take a look at what's going on. They should expect clear and continuing communication as the case progresses. They should expect in-person preparation. Before being asked to testify, nobody should agree to go on the stand cold as an expert. Every prosecutor should be willing to prep them, and really prep them, and also provide constructive feedback after the testimony. And finally, a sincere, competent effort to minimize the intrusion on the witness's time and a friendly, professional attitude. You should expect a prosecutor who doesn't give you a 5-day subpoena and say, yeah, you need to be there from the day the jury is picked until the day the verdict is in. That's ridiculous. The prosecutor should work with you to minimize the intrusion on the professional's time and to say, now, there's always a hurry up and wait. Unfortunately, no matter how much we try to time it, witnesses come in and we say, I'm sorry, somebody was sick or somebody got delayed. So you always want to bring work with you or a good book, but the prosecutor should definitely work on minimizing the intrusion on your time. That's everything I had, Joanne. I'm going to turn it back to you. Thanks very much.
Thank you, Roger. That was great. And just so everybody knows, what our plan here today is to, each speaker will just present a brief overview. We have learned from prior webinars like this that the best interaction is the questions and answers between the audience and the panelists. And so we've had a number of questions come up, and I'll talk about or ask the panelists to answer some of those. One of the questions is, let me find it here, we've got a whole bunch of them. Okay, the question is, what if a crime has occurred several days prior to being reported? How does one determine what evidence to collect, and who has input for determining what evidence is important? And Jim, you might want to try to answer this one to start, and maybe Jim would have something to add as well.
Okay, repeat that question for me, because I'm looking at a bunch of them. I don't see it on my list. Go ahead.
It's up quite high in the list here. It's, what if a crime has occurred several days prior to being reported? How does one, which is typically the way we do get these cases, right. How does one determine what evidence to collect, and who has input for determining what evidence is important?
Well, I think it goes back to a couple of things. One would be determining through a good comprehensive interview, and we in law enforcement, we're going to call it our victim, through a good comprehensive interview, what exactly occurred in that particular case and what would be probative and what would be important to try to collect. Then, based on that, coordinate with your forensic nurse examiner and determine exactly what areas or what items would be most appropriate or that you'd want to collect. Now, I would always err on the side of collect as much or more than you think you're going to need in areas that, maybe the victim didn't disclose that her breasts were swabbed. But I can tell you through many, many of our cases that we're linking together, breast swabs are becoming so critical in the DNA process. And so sometimes during these incidents, because of the trauma, because of the suddenness with these victims and how these crimes occur, sometimes they don't always remember exactly what had occurred. And so I think based on the information you get from your victim, based on your experience and the best practices in talking with your forensic examiners, I think over-collecting is probably the key. And, I think Jennifer talked about going, beyond 120 hours. Maybe the opportunity to collect forensic or biological evidence may not be available, but you certainly can document injury, and you certainly can document anything else that may assist in furthering the case.
Absolutely. I think that's so critical, especially when we know that the majority of these cases are going to end up resulting in a consent defense. And, we always talk about whether it's 72 or, 120 hours or 96 hours. And I think the question is there a potential for injury? And I think we are doing a lot better, but I still think that people tend to still think about the forensic exam and biological evidence. Jennifer, did you have anything else that you'd like to add to that?
I guess what I would say is that the critical piece that Jim touched on was that he's collaborating with and talking to his nurse examiners. He's finding out based on the information we know about this patient, is evidence collection worthwhile? Is an examination worthwhile? Mm-hmm. The collaboration with the nurse examiner or the forensic examiner, I think, is the key part. Not making that decision in a vacuum.
The other thing that I heard Jim talk about was the fact that history, and of course the victim is one crime scene, and that these cases typically involve multiple crime scenes. And so again, history and going out there and following up with what the victim has told us. Roger, did you have anything to add to that?
The only thing I would add is that the team approach is best, and there are definitely things that sometimes the prosecutor at least hopes will be of legal value. In other words, it's great to have the DA in on this as early as possible. So another good practice is for prosecutors to be involved in these cases very quickly and very early. That too is part of the team approach, so that the DA can also weigh in and say, what would be great if we had this? This would be fantastic. That really speaks to juries. It's really worked in this jurisdiction. Again, just for that other perspective. Law enforcement generally has a good sense of that as well, but it's great for the lawyers to weigh in if they can, because they have usually the best sense of what's going to play in court.
Great. Jennifer, I have a question from an audience member for you, and I have to confess I'm not quite sure I understand the whole thing, but it says if JCAHO, which is the Joint Commission,
yes,
requirement that nurses in hospitals collect evidence, does it blur the line about if collection of evidence is criminal justice or medical?
I think that the Joint Commission statement in recent years that evidence collection off of these patients, not just sexual assault patients, but other patient populations we see, actually makes the line very clear that it is a medical practice expected in emergency departments at the very least. So to me, it actually helped unblur the line that has been blurry for some time, and it has made it very clear, because certainly the Joint Commission does not have any authority over any law enforcement agency, but they do have authority over agencies who choose their accreditation. And so to me, it clarified the line. Does that answer the question? Hopefully it does.
I think it does. There's a question here. It says, is critical thinking evaluation on a case-by-case basis a good approach? Jim, did you answer that in text?
I did put something up there based on that, and I'm assuming by critical thinking they're referring to maybe staffing of cases, reviewing within your own unit or within your own team certain cases. That always is, the more input, and well, I caution, the more input is not always necessarily the best because of everybody's opinion. But if you're all on the same team, you're on the same pages, you're working towards the same goal, I think to critically look at these cases and review them. And I don't know if they're talking, maybe post where we were successful in a case and maybe post where we were not successful in a case, and really looking at what are some of the things we can do better, and what are some of the things that went really good that we need to emphasize in the future in order to ensure that we're providing the best service for our customers. And I don't know if that's exactly the point of the question or not.
Yeah, I actually read it differently. So if perhaps the person who typed that question can clarify, I was actually thinking it was more, based on history, the interview, that we respond and act in response to the information we're being provided. That's the way I took it, versus an evaluation.
Okay.
Or a systems review, but I could be wrong. So if that person would like to clarify, we'd be glad to try to address this again. And you'll see that Jim is putting some polling questions up, and we asked, in general, who is responsible for the crime scene investigations in your jurisdiction? Combination of detectives and scene investigators, 40%, detectives 48%. Okay, I'm going to go down and try to answer some more of these questions. We might take an opportunity or take this time to address part of VAWA 2005. Jennifer, do you want to start with that while I start going through some of these questions?
Sure, I can do that. Is it possible you can pop up my slide there? Thanks. The example that is in front of you now is an example from a system that was developed in 1998 in the state of New Hampshire, so a little before the VAWA compliance issue, and it created an anonymous evidence collection system for adult sexual assault victims, where the victim could, the nurse examiners wanted the option of giving victims who were coming in for health care saying, I don't want evidence collection, I don't want to talk to law enforcement, I don't want to report the crime, the option of evidence collection, because we knew as time passed that evidence would go away. And so this system was developed then, and really embraced by the Attorney General's office there as the lead law enforcement in the state. So we were really able to move forward with an anonymous evidence collection that didn't involve patient names on the outside of the evidence collection kit, just serial numbers. And the crime lab was actually willing to house those kits for a period of time and return them to the law enforcement jurisdiction that was appropriate if the patient never did report. And at this point, 10 years later, that evidence is just being maintained by law enforcement at the local jurisdiction if it comes back from the crime lab, and it's being maintained there indefinitely, so that if patients come forward at any point in the future, depending on your statute of limitations, ours was quite long in New Hampshire, they were able to step forward and make the report then. But now with the VAWA compliance, a lot of states are moving toward really trying to find some anonymous, quote-unquote, or Jane Doe, quote-unquote, system of allowing evidence collection in these cases where the patient may not wish to cooperate with law enforcement, and different states are doing that in different ways. So, I think that all of the panelists probably prepared in one way or another to answer any questions folks might have on that. Is that helpful, Joanne?
Yes, I'm curious. Typically, law enforcement impounds property, and it is tracked back to a case number, a victim's name. So in this case, all that law enforcement would have had was a serial number. So how were they able to go back and retrieve those and connect them back to the forensic exam at the hospital or the facility?
It was the expectation that the law enforcement in the jurisdiction where the crime took place would, once the victim was gone from the emergency room, come and pick up that evidence collection kit, and they would actually create a case number based on that kit alone. So they would actually have a case number because they would have to log the evidence into the crime lab with that case number. And that the only thing in that case number would be the serial number for the kit and any other information from the kit that would be valuable for them should the victim show up on their doorstep and say, I've decided to report this.
Okay. And in the 10 years since that was implemented in New Hampshire, do you have any idea of what percentage of victims decided to report when they were unsure?
Well, the first couple of years that we tracked that, the time limit for reporting that was translated to the victim was a 90-day period. The crime lab would hold the evidence for 90 days, and then it would be returned to the local jurisdiction. So that information was given to patients. And in that period of time, for the first couple of years, if after 60 days there wasn't a report, there was never a report between 60 and 90 days. So that's the first thing. So then the days that the crime lab would hold it was lowered to 60 days. But I would say the number of people who have come forward is probably less than 5%.
And did someone contact those victims for follow-up or your patients for follow-up?
No, they didn't. And in fact, that is one of the limitations that we talk about when we talk to other agencies that are employing this approach, is that that's really a critical piece to work out between the forensic examiner program and the crisis center response, so that either one or the other or both are following up with that victim to say, where are you at? It's critical.
Yes, I agree, because without follow-up, I don't think there is going to be a shift.
I totally agree.
Yeah, and one of the problems, of course, is that most of the forensic examiner programs don't have admin time. I mean, most of the programs are using nurses that are being called out, and so without the admin time, if there isn't an advocate involved or an advocacy organization that can reach out to that person, I don't know how that's going to be done within forensic examiner programs.
Yeah, I think the advocacy piece is critical, because more often than not, they are going to be the one that is doing any long-term follow-up with the victim. So they really prove to be critical in all programs that I've worked in.
Absolutely. It was really interesting. I was just talking to an advocate yesterday, and they had gone out on a case, and the victim was really reluctant and unsure, but each step she would kind of go, okay. Her parents were really pushing the investigation and the exam and following up with the case, and the advocate said the detective did a really great job. Everybody was doing a great job, but in the end, the victim, after hours of being involved in this case, and it was a strong case that could have gone forward, she declined. And it was a really difficult situation at that point because law enforcement had everything they needed, and so the advocate was put in a position where all along she had said, this is your choice, you can decline at any point, but it's almost like at that point, law enforcement is saying, well, what happens if this guy hits again? A lot of people would be feeling very guilty about it. It was a stranger sexual assault, by the way. And in the end, the advocate said that, some calls had to be made as far as whether or not they were going to pursue the investigation and prosecution without the victim's cooperation. And in the end, the detectives actually did decline and back down, but it was a very difficult situation, and you could definitely see both sides of that problem. Okay. Anybody else have any comments about that issue? And I'm going to questions here. Got behind as we were talking.
Joanne, there is a question about the Jane Doe reporting affecting the multidisciplinary approach. I don't know if you see that one in there.
No, but I'm scrolling up.
It starts with what do you see the most valuable role that victim advocates, and we probably should talk about the advocates, can play in this process, and how does the Jane Doe reporting affect the multidisciplinary approach? Does law enforcement need to sit out on meetings regarding Jane Doe cases? And I guess maybe, well...
Yeah, and Jennifer, your case in New Hampshire was great with the serial number. I did get a call from a state yesterday, they're handing the kits over to law enforcement, but with all the identifying information. And so a question came up as to whether law enforcement would, in fact, run those victims. When the question first came to me, they said, is it commonplace for law enforcement to do criminal history checks on victims? And, of course, my answer was yes. We run criminal history checks on victims, witnesses, suspects. I mean, we like to know who we're dealing with. And then it came back, well, would you ever run it on a kit when a victim had not chosen to come forward? So I think, these are all procedures that really have to be worked out, because if we really follow the spirit of the law, the intention is, in fact, for that to remain anonymous, and for all the information to be given to law enforcement is, in fact, not in compliance with that.
And I think that the states that are probably struggling the most with this are the states that have mandatory reporting laws in one way or another regarding sexual assault. So the healthcare professional is obligated to make a report, but that report may be very limited, and in those cases, in those states, it isn't an anonymous system. It's an unreported system. It's a system where the patient, the victim, is not cooperating with law enforcement, but it's not a totally anonymous system. So that does complicate matters, and it actually makes the team approach and the team development of their system even more critical.
Yeah, and Jim, I think in response to what you were talking about, one of the trends or the things that I hear is that, you're excluding law enforcement from a process, and if we're going to, in fact, hope to hold more offenders accountable, we can't do that. We know that depending on sometimes advocates and maybe even healthcare professionals' perceptions of the criminal justice system, and in fact whether or not victims are re-victimized because of, and I'm not just talking about law enforcement. When I'm talking about the criminal justice system, I'm talking about jurors, which are all of our neighbors, that, until we can change society's views, the victim blaming that occurs in these cases, there are unfortunately many people who would dissuade a victim from reporting, and so sometimes I know law enforcement feels that they're being pushed out of this, and that can make a difference or impact the feeling that we're working together towards, common mission. There's a question that just came in. In our sexual assault kit, nail clippings have been removed. Is this a common trend with police agencies? Our lab initiated this. Jennifer, do you want to address that?
It looks like someone has, I'm not sure exactly who put in the answer, but I think that, I guess my standard answer to this is that I think that best practice is that your whole team, including your crime lab, is at the table discussing what components are in your evidence collection kit and why, and that should be based on either some measure of scientific evidence or at least what you know to be true about your own crime lab and their findings.
Right.
I think that different teams are removing different aspects of evidence collection all the time. There are places who have not had, for instance, pubic hair pulling and head hair pulling for a number of years based on what the crime labs have found or not found or found to be helpful or successful in their sexual assault cases, and there are some that still do it. And often that is based on what the crime lab has available to them, what testing they do, what they don't, what they're not capable of doing. So I think that the community-based team, including the crime lab, needs to be a part of those discussions, and that the decisions need to be pretty scientifically based.
That is so critical. I was just doing training for Naval Criminal Investigative Services and the Coast Guard last week at the Federal Law Enforcement Training Center, and I asked them if they're still plucking head and pubic hair, and the answer was yes. But then somebody advised me that USIL has advised them that they will no longer do trace. And so, it's a situation where, again, we're doing something just because that's the way it's always been done, and nobody has asked, why are we doing this? And, of course, I feel very strongly about not submitting victims to that kind of torture, essentially following a sexual assault, especially when it's not necessary.
I totally agree.
Okay, I'm trying to get through questions here. Well, somebody moved my question. There was a question about, okay, do you have an example of physical evidence that was handled improperly and became a problem? Did one of the panelists answer that question? Was that you, Jim?
Yeah, where we had actually lost charges. It really wasn't the mishandling. It was the problem that a lot of us are seeing with our crime labs and the lack of staffing or the lack of having adequate crime lab folks to process all this evidence that we're now giving them and expecting to get back within a week. So that became a problem, and we actually lost, not the case, but we lost a felony charge because we had not followed through and had those items tested. I know there are some analysts and some crime lab people on in the audience as well, and I'm sure that, like Jennifer said, it is critical to have your crime lab, maybe not a member of the team, but at least an associate member of the team as you discuss these protocols or these guidelines and some of the issues that you're having with evidence.
Actually, I think that's a really important point, and one of the things that we're referring to is the Sexual Assault Response and Resource Team. Typically, when people talk about SART, they're talking about law enforcement, the forensic examiner, and the advocate. But I think it's it's very, very important to effectively work in a multidisciplinary team that we meet with researchers, our crime lab people, the prosecutors, mental health folks. I was really, really fortunate in San Diego because we started our DNA lab in 1991, and the PhD that came in to start our lab was just brilliant. He's just one of my absolute heroes out there, and so I was very fortunate to have that lab and one floor above my floor. And so we had constant contact every day, and he would attend our briefings, especially back when we were having to compete with homicide and back when we were doing RFLP, and basically the defense would just exhaust our resources by wanting us to test all 50 items. And so another answer to this question is that you need to sometimes explain why you didn't test the evidence or why you didn't get the results. For example, the forensic examiner doesn't examine and doesn't see anything. There are no visible findings, and so calling that forensic examiner in to testify that, in fact, the findings are consistent, if in fact they are. We had to do that a lot because, as we've talked already about the CSI effect, and, the jury just believes that you should be doing DNA in every case.
Now, Roger, have you had evidence excluded because of mishandling or lack of chain of custody? Is that anything that you've had to deal with in court?
Yeah, I have, and it's tragic. It happens. The two examples that thankfully, I've worked in places where I really had very, very good. I had terrific saints and really good cops, so it was very, very infrequent. But there have been a couple of cases where an improper chain of custody was just basically there was just a period of time where the evidence was unaccounted for. Period, and that's all it takes. And I think in that case, the judge decided that it would go to the weight and not the admissibility. In other words, the judge, she went ahead and let it in, but the defense obviously had the opportunity to walk all over it, saying, well, who knows what went on for this 6 hours? And again, when you have 12 people, 12 citizens who are trying to determine whether or not a sexual assault occurred, and a lot of times juries are looking for a reason to believe that this didn't happen, not because they don't like the victim or not because they don't believe in the terribleness of sexual assault, but just because it's hard to pull the trigger on somebody and convict, particularly in something as muddy as sex. And a lot of people don't want to believe that this sort of thing could happen in their community, and it's just a little slip up like that can damage the evidence. And once it does, it damages the case.
Great. And Jim Cooney just advised me that I wasn't looking in the right place for the questions. So, audience, you'll be glad to know that I'm in the right place now. So we'll start to answer these other questions. We have a question from Valerie. How can we educate the client tactfully or gently when they are confused about our role as healthcare professionals and not law enforcement? So, Jennifer, I think that would be directed toward you.
Can you repeat that for me, Julia?
Yes. how can we educate the client or the patient tactfully or gently when they are confused about our role as healthcare professionals and not law enforcement?
I mean, I think that is actually part of the informed consent process with patients. Telling them what we do, why we do it, that really is all part of informed consent to me. So I think that, I mean, to a certain degree, each examiner is going to need to come up with their own routine practice of how to talk to their patient about, my name's Jennifer Pierce Weeks. I'm a sexual assault nurse examiner. This is what that means. I'm a registered nurse. You have to come up with your own standard approach to the fact that you're providing them with health care that happens to include evidence collection, and that's part of your job. And along with the informed consent process, their right to refuse it and what that refusal means. When we were talking about, I know this is a little off, but it reminded me of something when we were talking about the Jane Doe kits. A lot of folks are really starting to employ an informed consent procedure so that not only will the victim have the choice of having evidence collected anonymously, they will also be informed of what that could mean later on down the road, because it does impact what law enforcement can then do 60 days later when there's no crime scene other than that which was collected off the victim's body, and it may completely inform what the prosecutor will be able to do based on what is no longer left of the investigation. So, but the initial question, I think you really need to form your own way of informed consent for patients so they know who you are and that you're providing health care. We cannot misconstrue that we are somehow criminal investigators, because if that is what the patient thinks we're doing, then I don't think it would take very long for a defense attorney to come on up when I'm on the stand and dispute everything I have to say and do with my patient care, because they didn't think I was a nurse.
Yes, and I've actually been in a jurisdiction where the forensic examiner program is out of the Rape Crisis Center. And in this particular case, the director of the Rape Crisis Center actually wanted the forensic examiner to do time on the hotline. And, I think maybe Roger could address it as a prosecutor, but it seems to me that that would not be a very good practice.
And I'm sorry, Joanne, when you say the timeline, you're referring to?
No, what I had saw in this one jurisdiction is the forensic examiner program was out of the Rape Crisis Center, and the director actually wanted the forensic examiner to work the hotline.
Oh yeah, no, that's I don't think that's good practice at all. And the reason for that is because of something that Jennifer Pierce Weeks touched on. Actually, it's very, very important for SAPEs and SANES to maintain a certain distance from law enforcement. And I personally think that the best programs, the best examiner programs, are ones that are hospital based, not Rape Crisis Center based. Now that isn't to say that if somebody out there has a Rape Crisis Center based program, they should give up the ghost. Of course not. SANES can do a terrific job out of Rape Crisis Centers, and oftentimes, the bean counters, the accountants, those that are forming these things just sort of put them together because they think it's a natural fit. That being said, if a certain distance does need to be maintained between the medical professional and law enforcement, and that's because of the issue of bias. If it is perceived by the jury, because of the efforts of the defense attorney, the issue of bias is one of the most closely guarded, or exploring bias is one of the most closely guarded rights in the law. So a defense attorney will be able to really get at whether or not a scientific expert, i.e. the SANE, is a biased individual. In other words, can we really depend on what this nurse, this professional, or this doctor, whoever, glean this evidence for the body, and now we're going to rely on it to possibly put this guy in prison for the rest of his life. Can we really trust it? Well, is she truly an objective, distanced professional? Understand that she's a compassionate professional taking care of her patient. Is she somebody who's biased? And if you have evidence that sex assault nurse examiner has done something like work a hotline, or really, really involved themselves with law enforcement, or really hasn't separated themselves enough and maintained enough of a distance from the rest of the sex assault response team, you could have some real problems with bias. And not only that, but because of the Crawford case, there is the possibility that statements that would normally be, and it's a little bit beyond the scope of this question, we'll see if it comes up again, but statements that are made to healthcare professionals for the purposes of diagnosis and treatment, even though they're hearsay, are normally statements that can be repeated because, for exactly that reason, because for a long time in Anglo-American law, it's been believed that you won't lie to a doctor or a nurse who's trying to make you well. So therefore, statements that the patient makes to the SANE can be repeated by the SANE in court if for some reason the patient victim can't testify. Maybe she's died of an unrelated cause, or she's left the jurisdiction, or some other reason. So that's a good hearsay exception to have. But the Crawford case threatens that exception. Again, it's too much to get into right this second. But basically, if it becomes apparent that the sex assault nurse examiner is just too much a part of law enforcement, or just too wrapped up in the law enforcement function or the advocacy function, then it's very likely that the court will say that, you know what, statements made to her as a medical professional are just, they're not pure enough. They're also made to her in an advocate posture and an investigative posture, and therefore those statements can't be repeated. So for bias reasons and all for concrete Crawford reasons, SAFEs and SANEs really need to maintain their distance, and they really have to watch what roles they play. And that's one that I would not suggest that they take on.
Right.
And can I add to that, Joanne?
Jennifer?
I would just add to, because I completely agree with Roger, I would just add to that two things. If you are a SANE nurse working out of an advocacy center or law enforcement or whatnot, and I know some folks that are doing a great job doing that, you need to be just very grounded in being able to explain nursing practice, your scope of practice, your licensure, how that is governed, so that you can explain that you were not outside your role. That's going to be one key piece from the prosecution perspective, from the criminal justice perspective. Another key piece is that you explained to your patient who you were and what you did in the context of your exam, because you are going to be the party that's going to be able to educate both the patient and your other team members on what nursing is, what medicine is, what you do, and that regardless of the agency you work for, you're grounded in that practice, not the practice of advocacy.
Right. And that actually goes into another question that Barbara has asked, and I think it's a really critical issue. She says, in regards to Crawford, how does the presence of law enforcement and or child protective services in the emergency department threaten medical exception to hearsay? Will the forensic nurse be viewed as an agent of the investigational body? And so, of course, this is this issue about whether or not, we do a joint interview because of the impact of Crawford. So, Roger, do you want to address that?
Yeah, I'll try to address that quickly. Bottom line is this. The Crawford case changes the way that lawyers view hearsay. Prior to Crawford, prior to 2004, if a lawyer was trying to introduce a statement, let's say the patient makes a statement to the examiner, I was raped by a man, he's a stranger to me, he's Caucasian, he had a long ponytail, and he had really, really dark black hair. And that statement the victim makes, and then let's say later on, for whatever reason, the victim is unavailable to testify, and the prosecutor says to himself or herself, wow, I really want for the sex assault nurse examiner to repeat that statement because it's important for us. We don't have the victim right now, but this, again, maybe she is deceased or for some other reason she can't be called as a witness. Can the SANE repeat that statement that she made, that she was raped by a tall stranger with a ponytail? Because maybe that a suspect was picked up or picked out of a lineup, or who has the same type of hair, the same color, the same style. So the question becomes, can that statement be repeated? Well, again, for a very, very long time, statements to medical professionals for diagnosis and treatment have been admissible under traditional hearsay exception. Crawford threatens that, though. Crawford says, look, you can't just go to the book, the evidence book in your state, take a look at the statement and see if you can cram it into one of those traditional firmly rooted exceptions. What Crawford basically says is the watchword now is whether or not the statement was testimonial. In other words, when the patient made that statement to the SANE, was she making it in order to receive medical treatment, or was she making it to a police officer or somebody involved with law enforcement in order to crack the case, and knowing that that statement may make its way into litigation at some point. Because if that's the case, if the statement is deemed to be testimonial, then the Crawford court says the statement can't be repeated. And the reason is because there was no lawyer there was no defense attorney there at the time the statement was made in the clinic to cross-examine that statement. So therefore, that statement can't be repeated. So to get right to the question, if there's, if the sexual assault nurse examiner is doing her work and there's a detective in the room and there's an advocate or child protective services in the room, will the nurse automatically be seen as part of a law enforcement team? No, the answer is not necessarily. As long as that sex assault forensic examiner, again, as long as she maintains her distance, as long as she makes it clear to the patient, I am asking you these questions for your benefit, okay? It's not about this case, it's about you and your treatment. And sometimes even the identity of the perpetrator goes to the diagnosis and treatment, because the aftercare plan that a nurse will author or a doctor will author for a victim, for their patient, will be different if it's a known perpetrator than versus if it's a stranger. Maybe there's HIV prophylaxis that's necessary. Maybe there's a safety plan that has to be put in place. But again, it's a hard topic to really get into. But the bottom line is, if the nurse is an objective medical professional who understanding that she works with child protective services and she works with law enforcement, if she nevertheless maintains a professional distance and makes it clear that what she's asking is different from what the detectives are going to ask and for a different purpose, then she should be okay. I mean, there are two schools of thought on this. There's definitely a school of thought that says, let the SANE do her work outside the presence of CPS, outside the presence of law enforcement, so that it's easier to preserve her statements and to keep them non-testimonial. But there's a downside to that approach, and the downside to that approach is then you're asking the patient victim to recite the account of the events twice at least, and therefore, particularly with small children, you have the risk of saying things slightly differently from one telling to another, adding information, leaving information out, and it can be more traumatic for the patient victim to have to repeat this. So oftentimes it's nice for there to be a series of questions asked by different professionals at one time to get it all out of the way. Is it more problematic if you do that? Yeah, it can be more problematic for Crawford purposes, but again, I think if the SAFE is really diligent about maintaining our objectivity and maintaining some professional distance from the law enforcement function, the prosecutor has a fighting chance of saying to the court, look, Judge, those statements were not made by this patient to this medical professional for anything but for the patient's treatment, and you should be okay.
Right. We could obviously spend 2 hours just on Crawford.
Yeah, exactly.
That's a complicated issue, and it's being ruled differently in different jurisdictions by different judges.
Yep, it's playing out all over the country.
Right. There are two questions that we can kind of fold together. One of them is from Debbie. Would concerns about following protocols be minimized if teens called them guidelines? And then let me go to Robert's question. How can we ensure that our protocol is defensible and most effective? So maybe we could address the first issue, and Roger, I think that might fall to you. Again, what do you think about the idea of calling these things guidelines versus protocols?
I mean, I suppose anything that loosens them up a little bit probably is preferable, I guess, because once they're called guidelines, then the idea of sticking to them by the absolute letter doesn't become quite as important, because then if the defense attorney says, well, there's a guideline here that you didn't follow, well, exactly, counsel, it's a guideline. It's something that we're asked to follow and that we are, within our judgment, it's suggested that we follow, but in this case, and for the following reasons. So, yeah, I don't know that I would necessarily change the word protocol to guideline in every case. I think that has to be a judgment that's made jurisdiction by jurisdiction, but I can see why that would be advantageous. In any event, whatever you're doing, as a SAFE, whatever you're doing, if you're going to deviate from the protocol for any reason, here would be my best advice. Know what the protocol is. If the protocol is outdated, if it does seem erroneous, then work on getting it fixed, and be aware of the fact that while you're working on getting it fixed, you're still going to have to defend it or defend your deviation from it. And finally, when you do deviate from the protocol or the guidelines, whatever you call them, make sure that you have a written explanation and a very, very good answer in your head as to why you did what you did. As long as you can defend the answer on the stand, again, you should be okay. All of that stuff is litigation. It's the prosecutor's job to spin that in the way most advantageous to the case.
right? And whether they go back to the academy and get resources and what people are being taught. I know recently I had somebody say they didn't want to have training because the defense could then show that if they didn't do what they were trained to do, that they're going to be held liable. And I'm like, well, isn't this about doing the right thing? I mean, to say that we're not going to have training, we're not going to have policies and procedures so that we can't be held liable or accountable to them, doesn't seem to be what we're all trying to do here.
Yeah, you can't, exactly. You can't, I don't think you can, you can't get around some of the pitfalls of litigation, and you shouldn't try. I mean, the right thing to do is the thing that you want to do, and the most medically appropriate thing to do is what you want to do, or the most investigatively appropriate, depending on your role. And yeah, and let the DAs worry about how it's going to play out in court. That's our job. If we're not creative enough and we're not competent enough to spin those things truthfully to the advantage of the case, then we shouldn't be doing what we're doing.
I agree. Okay, there's a question, and Jim, I think you'll probably be able to answer this. Is it true that when there is no DNA evidence in a semen specimen, it's the result of the male having had a vasectomy?
That is one of the reasons why it might not be present, as well as maybe there's a medical condition, there's some medication they may be on. It doesn't necessarily mean that you cannot extract DNA from that sample. It's just a different extraction. Obviously, with sperm, they use the nucleus of the sperm to get the DNA, but you can also extract it from the semen as well. And not being a scientist and only basing my experience on what our scientists have told me, that's my best answer that I can give you.
Right. I know in San Diego we had a case where we were able to get a DNA profile from a man that had a vasectomy. And I, like you, couldn't go into all the detail, but I thought you did a good job there. Okay, let me go on to this question. Jennifer, I think you'll easily be able to answer it. How do we include breast swabs in our kit? We don't have a separate envelope for it.
Breast swabs?
Yes.
I think that to a certain degree kits are obsolete, and everybody needs to do their cases on a case-by-case basis and be prepared to add or delete evidence as necessary. But I think all you really need is the swabs required, the sterile water required to swab the breast, the ability to dry those swabs and to package them in either an envelope or a bindle so that they can be preserved and added to what evidence kit you do have.
Very good. And let's see, there's another question. Is there some sort of national standard defining the acute time period, 72 versus 96 versus 120? Does the FBI have a suggested standard? Jennifer, you can probably address the national protocol in that.
The national protocol presently gives 72 hours as the standard window of evidence collection. There are many states that have increased their hours to 120 for a variety of, again, community-based reasons. And it would not surprise me in the least if that window were widened to 120 hours nationally as we move forward and look at changes to the national protocol.
Right. And the FBI, for the person asking this question, is not the agency that would set a standard here. The Office on Violence Against Women, in partnership with the International Association of Forensic Nurses and a panel of national experts, met to develop the national protocol. So that is what you should be referring to. And we have a list of resources that will be provided to all of you, and I'm sure that has been listed on there as well. But I just want to remind everybody again, we always talk about 72 versus 96, and Jennifer talked about it, and Jim talked about it, but remember that in many of these cases, the biological evidence is not what is going to be most probative. What we're looking for most often is signs of force, injury, to overcome that consent defense. So you always want to be thinking, is there a possibility that there is still injury here? Is there, pain, burning, spotting? And if the answer is yes, then we should be getting an exam regardless of whether it's 72 or 96 hours.
And at the risk of adding one more thing to the things that I really think everyone needs to be thinking about, there are huge short and long-term ramifications to being sexually victimized, and sometimes I think that we are willing to toss out the mental health implications and the mental health symptoms associated with sexual assault in lieu of the physical symptoms because they seem more evidentiary in nature. So I think that don't forget that people have severe anxiety reactions, PTSD, symptoms, et cetera, that are all part of the overall diagnostic picture for this patient population.
Thank you. Here's a question. We had a problem with one law enforcement agency being upset that we do not follow their instructions, or that we did not follow their instructions to collect certain evidence. Apparently the law enforcement agency was trying to prove a false report. The question is, do they not then make us an arm of the law, thus putting us in a problematic area for the prosecution? I think we've actually talked about this in some detail regarding Crawford and this issue of being an arm of the investigation. I think what's most concerning here is this issue of the false report. Would one of the panelists want to try to address this question?
I'm looking at it, Joanne, and I would say it looks like what we've got is we had a problem with law enforcement agency being upset that we did not follow their instructions to collect certain evidence to prove a false report. Did they not then make us an arm of the law? Well, yes and no. I mean, I think the thing to keep in mind is that the physical evidence that is gathered by the SANE or the SAFE is almost always done at the behest of law enforcement. That is true, but that's only because law enforcement in almost every jurisdiction is the entity that investigates whether or not a crime occurred. So I would say that any evidence that law enforcement asks the SANE or SAFE to gather is generally appropriate unless it proves to be unethical or somehow detrimental to the patient, or unless there's some other compelling medical reason not to do so. The fact that evidence has been gathered, whether it's beneficial to the prosecution or whether it's beneficial to the defense, the fact that it's been gathered does not make, or the fact that it's gathered at the behest of law enforcement does not make the SAFE an arm of law enforcement. Because the SAFE is going to do her work the same, or his work the same, whether the evidence proves beneficial to one side or the other. It's not going to matter. The body's going to tell you what the body's going to tell you. The evidence is going to be what the evidence is going to be. And once it's collected correctly, packaged correctly, stored correctly, then it goes to the litigants. And it goes first to the prosecutor, but not only to the prosecutor. It then goes to the defense attorney, and then it goes to the court, and then it becomes whoever's it's valuable for. So I wouldn't worry too much about that.
Thank you, Roger. I think that was a great answer. Here's a question from Jean. Our facility is sending evidence with the patient. We do not currently store evidence, and actually this is frightening. Not only have I seen situations where evidence is being sent with a patient, but with victim advocates. So I think, obviously the issue is that we need to, for best practices, we need to have law enforcement capable, as Jennifer talked about New Hampshire, capable of collecting those kits and making sure that they're being impounded. Departments are going to have to come up with some sort of a record mechanisms like what they did in New Hampshire as far as getting a serial number and generating some sort of report that does get a case number so that these things can be retrieved. I don't know if anybody else has seen this issue both with patients. Obviously a chain of custody would be jeopardized there, and as far as victim advocates handling evidence, it would really open up the possibility for all kinds of problems, not with just that victim, but other victims within that agency that are being served. Does anybody else want to try to address that?
Well, I think by default, most of our forensic nurse examiners are going to be part of the chain of custody. And I think Roger would probably agree that our object is to shorten that chain of custody as short as we can in order to kind of prevent any defense arguments that the longer the chain, the more chances of error, the more chances of it being excluded, etc. So when you start adding, civilians, advocates, those folks who probably don't want to be involved in handling physical evidence in the case, because now they become, at least within our jurisdiction, if they get on the witness list as an advocate, they're probably going to be excluded from being in the courtroom with doing their job with the victim at the time of trial. And so we don't want to turn those folks into witnesses either for or against us, and I think you're right. It's an absolutely not a good practice to allow that to occur.
Right, and of course it's occurring because if you don't have law enforcement involved, then who takes the evidence if the forensic exam facility is not doing it? Which is, again, why communities are going to have to get together in a multidisciplinary group to resolve these issues.
Yeah, I got to agree with Jim on that, and I think with you as well, Joanne. That's very, very, very dangerous practice for a couple of reasons. One, if the evidence is in the hands of a victim advocate, even for a short amount of time, that doesn't mean the victim advocate has altered it in any way. I'm sure that almost never happens, but here again, that's terrific fodder for a clever defense attorney to say, wait a second, this advocate handled this evidence. Mm-hmm. This is a woman who never questions the allegation of an alleged victim. This is a person who has an agenda. It's very dangerous. And secondly, it's very damaging to the relationship between the victim advocate and her victim and the survivor, because now if she's, as Jim says, if she's subpoenaed and she becomes a witness, she can no longer provide that advocacy. So it's that really, really needs to be avoided.
Thank you. Here's a quick question for Jennifer. Do you have suggestions how to handle clothing that needs to be dried? In my state, the sexual assault evidence kit is to be sent to the FBI. They will accept clothing but stress that it must be dried. Law enforcement usually has a drying room. At the hospital, we do not. If something is saturated, it may take days for it to dry.
This is going to end up going back to the team approach as well, and I think it really does in most jurisdictions. If you, for instance, we work out, if we have saturated clothing, we already have worked out with law enforcement agencies the fact that the transfer needs to be in an immediate fashion. But in addition to that, if it can't be, with the crime lab, we have worked out certain manner of packaging the evidence. So we will use sterile paper sheets that are plastic on one side and paper on the other to fold in that saturated evidence and be able to package it in paper bags but it's still not, it's not plastic in the way that it's completely sealed in plastic, but it's wrapped in a manner that allows it to not leak through every paper bag you're putting it in. But again, I think it's going to depend on the crime lab that's receiving that evidence and the law enforcement agency that's receiving that evidence, so that your community, your forensic examiners, law enforcement, and crime lab work out exactly what am I going to do with this evidence, because it has to be transferred in a way that it's not going to mold or destroy any DNA material.
Yeah, this is all about taking theory, protocol, guidelines, and making it practice, is what exactly you're talking about. Jennifer, this is probably another quick one. I think there will be two different answers by you and Jim, so maybe Jennifer first. How long do you suggest allowing a swab taken by an investigator? And it wouldn't make a difference whether it was an investigator or a forensic examiner, but they want to know how long should that swab dry prior to impounding?
Totally depends on what you're swabbing, in my opinion. It takes significantly longer for a vaginal swab to dry than it does a buccal swab. Mm-hmm. So if you don't have a swab dryer available to you, and it's, for instance, a buccal swab, I would say that those are generally dry, in my practice, generally dry absolutely within an hour. But a vaginal swab, all bets are off. If you're just sitting there letting it dry, it could be the better part of a day. I totally encourage the use of swab dryers.
Right. And as far as the field goes, Jim, you've got an officer out in the field and they're collecting a buccal swab from somebody that they're suspicious of. What would your officer's procedures be?
I would probably have them get into their patrol vehicle and drive about 65 miles an hour and just hang it out the window as they're going. Just kidding. We don't want to do that.
I like that.
There's several options. We actually the cartons, the cardboard cartons that we actually collect our swabs in, they actually have vented holes in them. So we actually collect the swab, put it in the carton, and then open up that hole. They will dry in that carton. It may take longer than an hour. I, with Jennifer, strongly suggest one, that you go out and purchase a swab dryer as well, and make sure that that is those are cleaned in between drawings. But we've had, where we've been at scenes, we've had multiple swabs at scenes. How do you ensure that they're not being cross-contaminated? How do you ensure? Some of our homicide investigators would simply have a piece of styrofoam, and they would stick the swab in the styrofoam and wait for it to air dry. Now, that as long as you have control and custody of the item, it probably wouldn't be too much of an issue as far as chain of custody and contamination in the court. But these swabs and the sensitivity of the testing now has made it to the point that we have actually gotten profiles from our lab, from our DNA analysts who have been working on these swabs, that they're masked, they have gloves, and their DNA is actually shown on these swabs. So you need to be very careful and ensure that wherever you're swabbing the items, that the possibility of destroying or cross-contaminating or picking up other profiles on that swab is at least minimized or eliminated. And swab dryers, you know, you obviously can't drive around with a swab dryer in your car and a very long extension cord, because it just wouldn't work that way. But I would suggest that they will air dry in the cartons, but it does take a little bit longer for that to occur.
And in San Diego, we just put them into the paper envelopes, and they air dried. We didn't use dryers, and been doing that since we started doing it in 1991, and never had any problems. So, obviously,
and there are actually swab boxes that you can buy if you want to spend a lot more money.
Right.
That that have the perforation, so you can actually place the swab through perforation holes, and it will dry without even touching the sides of the boxes. They just happen to be more expensive, so perhaps someone wants to invent a cheap version.
Good. Here's an interesting question. I've been hearing this coming up recently. Is there any value in using an audio tape of the nurse's interview with the patient? Jennifer, do you want to answer that?
Sure. I think that there are so many questions associated with this. I personally am opposed to it for a variety of reasons. I do not wish to be held to the standard that a forensic interviewer is held to in court. That's not my role. I'm not trained as a forensic interviewer. I take histories from patients. And in a medical legal case like that, I think that it wouldn't look all that well, and I'll toss this to Roger, if I'm going to do a play-by-play audio tape of my history taking with a patient. Even if I have that transcribed word for word and destroy the tape, destruction of anything in the medical legal exam is just a bad idea, and you're setting yourself up on the stand. So, I prefer to avoid this, but I welcome whatever Roger has to say about it.
Well, I think, Jennifer, wouldn't you also have concerns that your interview includes questions that are medical that should not, in fact, be part of the forensic piece?
Well, again, I don't so much separate those out. I think that they will certainly contain medical information that may not show up in the criminal trial. But I think we then we're just walking a fine line in the forensic interviewing realm, and I don't think we need to walk that line. We're not trained in that manner, and we should be taking our histories without that level of added documentation, I guess. But
Roger,
I don't think there are things that should be. It sort of sounded a little bit like we would be leaving things out if we didn't, and I don't subscribe to that belief. I don't think there are things that are going to be left out of my history taking, left out of my medical forensic documentation on a patient that would be captured in that audio tape. I think there are many things that are not medically related that come up, that are not evidence related that come up in our history taking with patients that don't necessarily get put into a medical record. And I think that the audio tape would remove all possibility of that happening. So I don't know. It's a very tricky and unanswered question. Hence the reason I tossed it to Roger for a prosecutor's opinion.
Sure, and let me just clarify. I'm sorry. Going back to the original question, I was listening to the answers. Are we talking about the viability of audio taping? And is it a good idea, preserving it, memorializing it?
Yes. Would it be a good idea for the forensic examiners to audio tape their interviews?
No, I don't really think so. I don't think that's necessary. The only thing that we ask as prosecutors is that whatever the patient tells them, we would ask that it be taken down as close to verbatim as possible, understanding that there are other needs. And there's generally a hierarchy that medical professionals follow. You know, protect myself, protect my patient, and then do whatever else. We do ask that examiners take statements as close to verbatim as possible, but yeah, I wouldn't suggest audio taping. I think that's just fraught with too much. It creates something that, you know, if the tape gets lost, suddenly there's missing evidence that can. I think it just creates more problems than it would seek to solve. I think a competent exam with that's well documented and properly memorialized in the form of a written report is enough. I wouldn't suggest audio taping.
Thank you. And here's a question from Debbie. Pennsylvania has just developed a standardized kit. Nail clippings and scrapings are now in the kit. If you recommend swabbing, how is that done? And I think that they must be talking about not just swabbing of the breast or the neck, but they're talking, I think, about swabbing of the hands and the nails.
Sure. Generally speaking, if you're swabbing the fingernails versus clipping, some people do both, but if you're swabbing the nails, then usually you're dampening, not saturating, but dampening the sterile swab and doing one hand at a time. But people have different practices. But that's generally what we do, is dampen the swab, use one swab, do all swabs of fingernails on the left hand with one, dry that, package that separately, do the right hand the same way. If you're talking about swabbing the hand, which in some circumstances that's the appropriate thing to do, as well as the nails, then it's the same technique. It's dampening a swab so that you're not. But again, you're going to ask your crime lab about this. But you know, you're trying to confine the evidence on that person's hand or under that person's nails to a limited, geographic area, that one swab. But again, talk to your crime lab.
Right.
I know our crime lab, similar technique, wet, dry. You want to concentrate as much of what you think is going to be biological evidence on one swab. If you swab each finger individually, you may get DNA, but it may be such a small amount that they can't actually extract anything from it. So you want to concentrate as much of the DNA onto one swab, and remembering that you also have to preserve generally half that evidence or half that swab for the defense, for them to test as well. So if you can, effectively wet and dry, but try to concentrate as much onto one swab in one particular area, and obviously left hand separate, right hand separate as well, just like Jennifer said.
Thank you, Jim. And here's a great question. At the suggestion of our crime lab, we've been using dental floss and getting DNA from the mouth where the oral swabs are negative. Our record, and I'm assuming our record for obtaining a DNA profile, is 4 days after the assault. Are other programs using dental floss? Jennifer, can you answer that?
Are they talking about getting DNA from the victim, or are they talking about getting suspect DNA using dental floss?
I would say suspect DNA.
Well, I couldn't speak to too many programs out there. I know there are a few that I'm aware of that use dental floss, and some have been published in a limited way. We don't do that in our practice. We haven't currently employed dental floss, but I think, again, if your crime lab is saying, hey, we get much better DNA using this technique, then not only should you be doing it, but you should publish it so the rest of us know that.
I know Diana Fogno at Palomar Hospital was doing this, and I don't know what the results were, but I have heard this. I think what's important here, and Jennifer has talked about this several times, but communicating with your crime lab. And if your crime lab is telling you that there's a possibility, then, as Jennifer said, do it, and hopefully we'll get results and we'll get this out there to everybody else. Okay. For those states that have implemented anonymous kits, how has the percentage of reporting been affected? I think that we've talked about this. Jennifer talked about it somewhat. I think the agency out there that will be able to give us a clearer picture is the Department of Defense with the restricted versus unrestricted reporting. I haven't actually seen too much else published about this. Does any of the panelists have anything different about numbers from what we've already talked about?
I totally agree. I think the Department of Defense is going to have the best numbers. They keep the best records of it, and most states have not been doing anonymous in a long enough period of time to be able to answer those questions. But lots of times the fear was, oh, we're going to get many more patients now that we have this system. That absolutely did not happen to us in New Hampshire. It was still a very limited number of patients. 85% wanted to report to law enforcement.
Yeah, Jim responded about this. I understood that the dental floss was being used on the victim, but I'm assuming it was being used following a suspected oral copulation, and that the dental floss was being used to try to obtain a DNA profile from the suspect. If I misunderstood that, please clarify again. If a Jane Doe decides to report, who does the law enforcement personnel, how does the law enforcement personnel know which kit is hers? Does the hospital keep the info, or does the victim need to know her number? Again, Jennifer talked about a system in New Hampshire. Different agencies are doing it in different ways. Jim, do you want to talk about how you're doing it in Phoenix?
We are exactly gearing up to do that, and we have had our team meeting with all the disciplines to discuss the best way to approach this, and we have looked at some of the guidelines that are out there already in New Hampshire, Maryland, Oregon, and have kind of taken a little bit of each one of those guidelines and put it together. What we're decided to do is we're putting it on the forensic nurse examiners. We're going to put it right in their lap, and they are actually going to put together a system where the patient, the victim, when they do get the exam, they will be given basically a number. I hate to minimize it as such, and that's the report number through the nurse examiners. And when they decide, or if they do decide to notify law enforcement, then they will call law enforcement in the jurisdiction where it occurred, and law enforcement will then in turn contact our forensic nurse examiners, and we will match up that number with the examination kit, and we'll start from there.
Okay. And Jennifer, this goes back to your experience in New Hampshire. It says, in the New Hampshire experience of Jane Doe reporting, did any of the 5% of cases that eventually were authorized or where the victims decided to go forward, did any of those result in successful prosecution? And if so, was it because DNA evidence was recovered in the case?
I can say yes to successful plea bargaining. I can't speak to whether or not they ended up in successful prosecution, but again, less than 5% of the cases. But for sure, I'm acutely aware of one particular case where the woman was actually raped twice by the same perpetrator, and had gone and had an anonymous evidence collection done the first time, and then when he reappeared several months later, did the same thing and eventually made a report, and his DNA was in both evidence collection kits, and successfully plea bargained him to prison. But beyond that, it's all very anecdotal. So,
which is a little bit disappointing, because you've got communities like Wilmington-Ledre in Hennepin County, Minnesota. You've got states like Maine that have had anonymous reporting for a number of years, and it's actually a little disturbing to me that there isn't more out there published about what happens with these cases.
Yeah, I think that the follow-up is going to be the key to that, Joanne, and really doing some serious tracking of that with nurse examiner programs or advocacy programs to find out what's happening.
Right. Okay, let's see. There's a question about, again, sources, journals, websites, should we go to for the latest best practice, and we're going to provide a pretty extensive list of resources here in just a few minutes. Just trying to look to see. Oh, there was a, Barbara had responded about the dental floss, and she said that they stopped doing it because of concerns of pathogens. I'm looking for that question. Does anybody see that?
That makes sense to me.
Yeah,
well,
it does.
Well, that just makes sense. Although there's no data on, there's no data available to us in the literature and research on HIV, for instance, transmission from oral penetration. But you can imagine that using dental floss, often you will disrupt the gum line and disrupt what is intact tissue, and you could provide an avenue for a pathogen to go in and infect someone, not just HIV but other pathogens as well. So, but again, there's nothing in the literature that I'm aware of that supports either the acquisition of HIV at a certain rate through the oral cavity or what Barbara is suggesting either. I haven't seen anything. It doesn't mean it's not out there, but I haven't seen it.
Okay. I don't understand this question. What is behind victim advocate in the green choice? Does anybody understand that question?
I didn't understand that one either. I have to get a clarification on it.
Okay. Does anybody else see a question that I've missed that we think we need to start wrapping up in a couple of minutes? Is there any question that the panelists see that they would like to try to answer in the limited time we have left?
Well, there were a couple questions on the corrections environment, and I'm not sure if they're asking for a question from a legal standpoint. I know there was one that was, can you address the issue of sexual assaults in correctional facilities and the role of the forensic nurse examiner in evidence collection? My impression, again, from a legal standpoint, and my impression when I read that question was the answer is that forensic nurse examiners are going to be doing the same work. And again, they're going to be examining patients in a correctional a sexual assault in a correctional environment the same way they would anywhere else. I don't think from a medical standpoint their job would change. There was another question that asked if well, I guess the statement was that medical policy requires no nurses can collect forensic evidence. Please give an example of giving first aid without disrupting evidence. I'm not sure that I could. I mean, I'll toss this to Jennifer, but it seems to me that I think what's medically appropriate has to be considered first and foremost. And if first aid disrupts evidence, then first aid disrupts evidence. I'm not sure, but I'll toss it to Jennifer to see if there are protocols that medical professionals attempt to follow in order to sort of walk that line.
And Jennifer,
can you just read that again, Roger, just because I'm not looking at it?
Sure. The question states, corrections environment, medical policy requires no nurses can collect forensic evidence. And then the next sentence is, please give example of giving first aid without disrupting evidence. Thanks. I don't fully understand it, but I'm not sure that can be done.
Yeah, I do understand what they're saying there, and that is not the situation in all Department of Corrections. I've done a lot of training with corrections personnel. So apparently in this jurisdiction what they're saying is that they have a policy that requires...
It disallows.
Yes.
Right. And some of that, some of that in my conversations with some corrections folks as the PREA Commission has moved forward and they have tried to implement how they're going to handle sexual assault response, some of that has to do with when correctional officers are the ones who are the offenders. And is that putting the nurse who also works in that system, is that putting that examiner in a position, an uncomfortable position because they're taking care of an inmate or providing a forensic exam on an inmate who was assaulted by a colleague of theirs? And so there's a whole dynamic that goes on in the corrections world that doesn't necessarily enter into the civilian world that I think probably plays a role in some of that. But obviously, the first aid piece is what it is. It's that way in the emergency room too, not just corrections. I mean, first aid, first response stuff totally can interfere and does interfere with evidence collection and still has to come first. I think there are more instances, however, where the evidence is routinely destroyed when it doesn't need to be, when the forensic examiners can be working collaboratively with the rest of the first response approach, if you will, whether it's the ED staff or whatnot. So I think it has to be looked at, again, from the team perspective, and how can we respond to this, but there are always going to be circumstances where the evidence is destroyed in the process of caring for the patient.
Thank you. So we need to wrap up. Again, I want to apologize to the audience for not finding the correct place for the questions, so I didn't get probably as many as we could have if I'd have been in the right spot to begin with. But based on the number of people still in the audience, we haven't lost too many people. Roger, Jennifer, Jim, any closing remarks?
No, except this, the only thing I was going to say is this is fantastic. There may be some lingering questions here. I think, I'm not positive, but I think if our contact information isn't up, I would, maybe we can get it out to the audience somehow, but I would definitely encourage anybody who has remaining questions. I'm sure I speak for everybody in the panel when I say that we'd be happy to try and answer them offline if anything lingers out there that we didn't get to.
Okay, and Jim, if we could have our resources.
Yes, I'm pulling them up right now. And while we're waiting for that to load up, Roger, just to address your point, that's very generous of you, and this is Jim Cooney, by the way, from the Government Innovators Network, and I will be issuing a feedback form via email to everyone who has attended, and if the panel would like, I can include your contact information for any unanswered questions in that email so that people have it.
Yeah, that's certainly fine with me. I'd be happy to answer any questions I could.
That's fine with me as well.
And me.
Yes, and Joanne as well.
Great. All right, so everyone should be seeing, this is the event page, which is presumably how you all logged in today. And now I'm going to go to the resources page. And Joanne or the rest of you, if you'd like to just call their attention to some of these great links that you've given us.
Okay, we have crime scenes and a crime scene investigation, a guide for law enforcement. There is the National Protocol for the Sexual Assault Medical Forensic Examination that was developed in 2004, published in 2004, and that's the organization or the agency that would provide you with the guidelines of 96 or, et cetera. Sexual Assault Forensic and Clinical Management, a virtual practicum. This is also done in cooperation with the International Association of Forensic Nurses, with funding by the Office on Violence Against Women. This is very, very exciting if you haven't seen that yet. I published a series of promising practices, and I have written about some of these issues, implications of VAWA 2005 for the forensic exams, sorting out fact from fiction when we talk about some of these things. Can it really be done? Biological evidence in the period of time that it can be recovered, and all of those are available on my website, free for download. An example of an electronic form for documenting evidence from medical forensic exams is available. To find out whether or not your state has a law mandating medical professionals to report suspected cases of sexual assault, there's an interactive map that is available on the American Prosecutors Research Institute website that you can find out exactly what's going on in your state. DNA guidelines, this is available from the National Institute of Justice. Videos available on DNA critical issues for those who work with victims of crime. And then there's recently a FAQ that was published by the Office on Violence Against Women on anonymous reporting that's available as well. And we've provided links to national organizations such as the IFN, the National Center for the Prosecution of Violence Against Women, hosted by the American Prosecutors Research Institute, and Violence Against Women International, the National Sexual Violence Resource Center, and of course SANE-SART Guide. And so hopefully those will answer some of the questions that many of you asked about how to get to these websites. So Jim, if you'd like to take back over, Jim Cooney.
Sure, Joanne. And first, let me just say thank you to our wonderful panel today. This was easily one of our most successful events that we've ever done in the 3 years we've been doing them. We had a great turnout and some great questions, and you managed, despite your apologies, to get to so many of them, and that is really wonderful. And it's great that you're offering yourselves to answer further questions. So thank you to our panel. Thanks to the audience for attending for the duration and for asking such great questions. And thank you also to NIJ and in particular to Melissa Marmer for putting this great panel together. I don't thank her enough. And what I'd like to, well, first of all, I'd like to tell you that we answered a lot of polls today, and we have a few more polling questions that we never did get to, but I think they're worth posing to you. So in that feedback form that I mentioned, which I should be sending out within the next 24 hours via email, included in that form, I'm going to append some of the polling questions that we didn't get to. So, you know, they're optional, of course, but if you feel inclined, please answer those questions, and I'll provide those with the rest of the polling results so that you can view them. And we'll be posting the polling results, all the presenters' slides, presuming we get their permission, and the recording of this event on our website. All of that will be available within 2 to 3 business days. And finally, as I mentioned, we do have a chat room. And I'm going to show you in a moment how that's going to look. But basically, you're going to go to our homepage, the Government Innovators Network, at www.innovations.harvard.edu. And in the top right corner, you're going to see a section called What's New. And there's a link there that I'm going to show you right now. And you don't need to install any software in order to use this chat room. It's text-based, and now you should see my browser window. So see under What's New, we have, oh, that's not right. Oh dear. Sorry for the delay. I need to call up the appropriate link. Bear with me.
Jim, can I ask you a question?
Yes, please.
Was the audience able to see all the questions in the question
No,
answer?
They were not.
Okay.
So they only saw the questions that either Jim answered in text form or heard the ones that you posed verbally.
Okay.
Thanks for buying me a couple seconds. Now I have the correct link up, and as you can see, it says Chat Room Reception, Sexual Violence and Evidence Collection. All you have to do to enter our text-based chat room is click on that link, and then it's going to ask for your name, which you can type in, and then click the Sign In button. And at that point, you should be entered into our chat room. And some of you have already beaten me there. Great. And we have about 24 spots open. And you can type in comments back and forth to each other. You can also share URL links. They'll be automatically hyperlinked. So you can share resources with each other. You can exchange contact information. And it's really just a great networking opportunity. So I encourage you, all of you who are able, to come join us in this virtual cocktail reception. And thanks again, everybody, the panel, the audience, and NIJ for making this event such a great success.
Terrific. Thank you all.
Jim and Roger and Jennifer, do any of you plan to go into the chat room?
I can for a little bit.
Sorry.
I heard Roger